or if they don't know what's on the criminal record, they can get a rap sheet. So if someone was arrested in Chicago, they can obtain their record of arrests and prosecutions, known as the rap sheet, from the Chicago Police Department at 3510 South Michigan Avenue. Rap sheet's a document that has information about any arrests or offenses that they have been charged with, along with the outcomes. Getting the rap sheet is helpful if the person is not sure what they're arrested for, what the outcome of the case was that they were charged. Very helpful for the attorney to, like myself, also to review someone's rap sheet so I can make a determination. So even if the person themselves is not really aware like what the outcome was or how to ascertain that by looking at their rap sheet, by having the rap sheet, that's really helpful for the attorney to look at and get a sense of what criminal record relief they may be eligible for. Okay. So while you're getting your rap sheet at 3510 South Michigan, you can also ask for your statewide criminal history transcript, and I'll talk a little bit more about that later on. So how do you get the rap sheet if you're in Chicago? If you're in Chicago, you can go in person at 3510 South Michigan to get fingerprinted, and they're open Tuesday, Wednesday, or Thursday between 8 a.m. and 1:30. You must bring a valid driver's license or a state ID, and there is a $16 fee, so people should be aware of that. And then the rap sheet will be mailed to the person in 7 to 10 business days at the address that they provide. So how do you obtain a rap sheet if you're not currently living in Chicago? So if you have records in Chicago, but are living out of state, you can arrange to get fingerprinted at a local police agency near you, and you can submit your request by mail. You will need to include your fingerprints along with a copy of the valid driver's license or state ID and the $16 fee, and then also a self-addressed stamped envelope with 2 stamps and a letter explaining briefly why you're requesting it, along with a contact number. So what is an Illinois statewide, I'm sorry. What is an Illinois statewide criminal history transcript? So if you have records in other parts of Illinois, 2 places you can go to get fingerprinted and initiate the process to request your criminal history transcript are a law enforcement facility located anywhere in Illinois, or a licensed fingerprint vendor. Before doing that, you should definitely contact the facility vendor in advance to inquire about the process, such as hours, fee, etc. And then your criminal history transcript should be mailed to you, again, at the address you provide. So what is expungement? So if someone is arrested or charged with an offense, but they were not convicted, they can ask the judge to expunge their record. And I emphasize that, and I'll talk a little bit more about sitting in a little bit, but so if you are not convicted, you can ask that that record be expunged. If the record is expunged, that record will essentially be erased. And this can be helpful in looking for an apartment or applying for a job. Please note, though, that not all records are eligible for expungement, which leads us to what is sealing. So if somebody was convicted of an offense, that record is not eligible for expungement, unless there's an eligible cannabis conviction, which I will discuss later on. So they still have a form of relief available to them. You can ask a judge to seal this record. Sealing a record limits who can view the record. A sealed record can still be seen by some employers, but it can still be helpful in getting some jobs or applying to an apartment. Private landlords and many employers cannot view sealed records. One thing I will note is that a lot of people ask me, a common question is, which one is better? Expungement is a much more, it's a better remedy. As I mentioned, it essentially erases the record, and many employers can see sealed records, like felony sealed records, but what expungement, it pretty much erases it from your record. But the biggest difference, of course, is whether you were convicted of the offense or not. So if you were convicted, you're now eligible for expungement generally, but you can still get sealing, which is essentially substantially limits you can see this record. Not all records, again, are eligible for sealing though. So housing and criminal records. How can sealing or expunging your criminal records help with obtain housing? Well, under the Cook County Human Rights Ordinance, criminal records that have been sealed or expunged cannot be considered. So when a person applies for housing, records that have been sealed or expunged can be considered. And then also, under the Illinois Human Rights Act, people who have arrest records, which includes expunged, sealed, and also juvenile records, also those cannot be considered. So it can't be denied housing because you have sealed or expunged records. Okay. So what if you have convictions on your record? So in here, I'm referring to records that have not been sealed or expunged. So you have a conviction on record, hasn't been sealed. Under the Just Housing Amendment of the Cook County Human Rights Ordinance, there's a two-step screening process. First, you have to be deemed pre-qualified. So this is based on factors such as income, rental history, and only then, once a tenant has been determined to be pre-qualified on these factors, then a criminal background check can be conducted. However, one thing to note is that criminal convictions that are more than 3 years old cannot be considered. So if you have a record that's more than 3 years old, that shouldn't even be considered at all. Okay. So convictions that are not more than 3 years old can be considered when denying an applicant for housing under the Just Housing Amendment. But even then, an individualized assessment must be performed before doing so. So what factors can be considered in the individualized assessment? So I'll go over some, but I have them listed here. The nature, severity, and recency of the conduct underlying the individual's specific conviction, the nature of the individual's sentencing, the number of the individual's convictions, etc. Okay. So after the individualized assessment is performed, an applicant can still be denied, but the individualized assessment has to show that denial based on the criminal conviction is necessary to protect against a demonstrable risk to personal safety and or property of others affected by the transaction. However, before getting denied, the applicant must be provided with a copy of the tenant selection criteria, a copy of the background check used, and they should be afforded an opportunity to dispute whether the information is relevant or accurate. If they're denied, they must be notified why, and the applicant's criminal history should not be shared. Okay, so expunge or seal record, how is that helpful in terms of finding employment? So under the Illinois Human Rights Act, employers who are covered, so those with 15 or more employees, it prohibits employers from refusing to hire somebody because of their arrest record. Again, an arrest record includes expunged, sealed record, and juvenile record. So if you have an expunged record or a sealed record, an employer cannot refuse to hire you based on those records. However, some employers, such as school districts, government employers, and private employers that require background checks as part of their evaluation process, can request information regarding a sealed felony conviction and use that in making a hiring decision. So as I mentioned, this is why expungement is a greater remedy than sealing. However, for many employers, a sealed felony conviction still cannot be seen by employers. So many employers cannot make decisions based on a sealed felony conviction. So it still provides relief to individuals with sealed records. Okay. So the Job Opportunities for Qualified Applicants Act. So here is for folks who have convictions on the records. Again, these are people who have convictions that have not been sealed, right? So under the Job Opportunities for Qualified Applicants Act, employers with, covered employers with 15 more employees are prohibited from asking applicants about their criminal history into after they are deemed qualified and get an interview, or into a conditional offer of employment is made if the employer is not interviewing applicants. And for people in Chicago, the Chicago Human Rights Ordinance covers employers with less than 15 employees. So what's important to note here is when someone is applying for a job, employers, these covered employers aren't able to ask about their criminal history, for example, in the application. Right? So at the application stage, they're prohibited from doing so. So they should not be seeing questions about their criminal records in the application. So there are some exceptions, right? Some employers, and there's some situations where it doesn't apply to them. So if it's mandated by federal law or state law to reject applicants with certain criminal records. So if the person wouldn't be able to get a bond because of that record, and then the Chicago Human Rights Ordinance has almost identical exceptions as well. Okay, background checks. Under the Fair Credit Reporting Act, before obtaining a criminal background report, the employer must get your written permission, and they must inform you that they might use the information obtained in the report in their decision regarding your employment. And the employer is planning to make a decision not to hire you based on the report they obtained. They must provide you with a copy of the report, a summary of your rights, and allow you time to dispute and correct information in the report. So before refusing to hire an applicant with a conviction on the record, under the Illinois Human Rights Act, most employers can refuse to hire someone because they have a conviction. And again, this is someone who has a conviction on their record that hasn't been sealed, unless there's a substantial relationship between one or more of the previous criminal offenses and the employment sought or held, or the granting or continuation of the employment would involve an unreasonable risk to property or to the safety or welfare of specific individuals of the general public. Now, before they make the decision not to hire, though, employers must still consider mitigating factors. So the following mitigating factors must be considered before an employer refuses to hire somebody with a conviction on the record. And I'll go over some, but I have them listed here. The length of time since the conviction, the number of convictions that appear on the conviction record, the nature and severity of the conviction, and its relationship to the safety and security of others. So many of you are probably aware by now that recreational cannabis use is legal in Illinois as of January 1st, 2020. Illinois residents may possess up to 30 grams of flower, 5 grams of concentrate, or 500 milligrams of cannabis-infused products such as edibles. And for non-Illinois residents, it is half of that above. Are there restrictions on use of cannabis now that's legal in Illinois? Yes. Still legal to use cannabis in public, such as at parks, on a bus or train, in a car, or near children. A person can have cannabis in the car, but only if it's in a secured, sealed container that cannot be reached while the car is moving. Driving under the influence of cannabis is not permitted. Okay. Employers can establish policies that prohibit the use of possession of cannabis in their workplace. Employees that violate their employer's policies prohibiting the use of possession of cannabis in their workplace can face disciplinary action, including termination for violating these policies. Are there restrictions in the federal law? Again, yes. So cannabis is still considered an illegal substance under federal law. The use or possession of cannabis in federally subsidized housing is not permitted. So what if someone has been arrested or has gone to court for a cannabis-related offense? As I mentioned, cannabis is now legal, but in Illinois, but recreational cannabis wasn't always legal in Illinois. So if someone's been arrested, have gone to court for cannabis-related charges, they may want to seek legal advice to see what their options are. So New Leaf, Illinois, with CCH as part of this network, may be able to help them with expunging the record. So what is New Leaf Illinois? It's a network, statewide network of nonprofit organizations like CCH who can provide free legal assistance and potential legal representation to individuals with cannabis records. So if somebody has a cannabis record, or they're not aware they have a cannabis record, but they think they might, it would be a good idea for them to contact the New Leaf Illinois program. So they can either go online, fill out a quick intake form, and somebody can contact them and assess their eligibility, or they can call directly, and the number is provided here. Okay, so now I will open up for any questions. Again, I did provide our toll-free helpline if somebody has questions about their specific case or someone they know, and they can call this line. Okay, I don't see any questions. So if there is no questions, again, I'll leave the toll-free helpline number there. Feel free to contact this number, and we can do a full intake to assess. We're able to provide legal assistance, and we can go from there. Thank you, everyone, for coming. I really appreciate it.